To the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Quorum call.
Madam Speaker,
What about Ben Barnes? Is he? Is there?
Can you hit the bell, Sylvia? I don't know where all these people are. Is Moon out there? Oh yeah, can you hit Moon? Colleen, can you hit Moon?
I got him.
Ben. Mouse is in the Anna.
Has everyone recorded their presence? If so, the clerk will take the call. There being 115 members present, the House is now in session. The clerk will read a journal from the previous day.
Annapolis, Maryland, February the 25th, 2021.
Recognizing the majority leader.
Thank you, Madam Speaker. Move so much to be considered the reading of the journal from the previous day.
So ordered. Petitions, memorials, and other papers. Introduction of House bills. The clerk will read the bills and her committee assignments.
House Bill 1363, Delegate Carr, House Rules by order of Sylvia Seeger, Chief Clerk.
Clerk will read the bond initiatives and the committee assignments.
Introductory House Bond Initiatives number 22, referred to appropriations.
Let's do your judiciary. No, you take both these. Sorry.
Report of the Committee on Judiciary, report number 6. The clerk will read the first bill.
House Bill 411, Criminal Law, Law Enforcement Officers, Prohibition on Sexual Activity. Favorable amendments. Amendment number 1.
Recognizing the floor leader on the bill.
Thank you, Madam Speaker. I can pick it up. Wow, it's like old times. Thank you, Madam Speaker. Move so much be considered the reading of the amendments.
So ordered.
Amendment 1 is technical. Amendment 2 clarifies that this bill only applies while an investigation is still open, and it strikes exceptions for prior legal relationships. Move the amendments.
Question for the House is the adoption of the amendment. All in favor signify by saying aye. Opposed, no. The ayes have it. The amendment is adopted. The question now is adoption of the favorable report as amended. All in favor signify by saying aye. Opposed, no. The ayes have it. The favorable report is adopted. Are there any additional amendments to the bill or to its title? Gentleman from Carroll in the annex.
Thank you, Madam Speaker. I have a couple questions for the floor leader, if I could. There's some language in this bill. I think it came through an amendment that has piqued a lot of interest. And I know there are a lot of folks down here that want to defund the police, but I think this language defunds the police. So I wanted to ask about that if I could. Could you, Mr. Ford, could you speak to the genesis of the amendment that caused so much consternation in your committee during the process of voting for this particular bill? How did that come about?
Sure. So let me clarify first what this bill does. The intent of this bill is that the police should not have sex with people whose lives they can ruin. So it applies to law enforcement officers as defined as people with arrest powers, okay? So this is law enforcement officers who have the power to arrest. What the bill as introduced said was that during an investigation, the suspects, the victims, and the witnesses would be in this category. It's already a crime to have sex with someone in your custody. That applies both for prison guards and for police. So this would extend it to suspects, victims, and witnesses. So that's as far as we got. Now, what the two amendments do, the first one that we took, it clarifies that this only applies to an open investigation. So this is a very old investigation. Law is no longer in effect. But while this investigation is going on, it is highly improper for a law enforcement officer to be having sex with the individuals named. It could lead to them coercing a witness into sexual favors. It could throw the entire criminal case for improper conflicts. So there's lots of problems with it, and we're just trying to draw a bright line. Now, at some point along the way, there was a request that we specifically remove law enforcement officers who had a prior legal relationship. And believe me, I understand the concern that you're immediately thinking, what about a married couple that's employed in a law enforcement agency? And what we ultimately decided was that it was an interesting theoretical concern, but unlikely to actually materialize in the real world. Our chair is himself a state's attorney, a prosecutor, and we do not need to write into such a level of detail every aspect of this could happen, this could happen. That's where discretion comes into play. And so the other harm is this. If you put an exception for prior legal relationships, that language that we struck doesn't say when that prior relationship was. What if it was 20 years ago? It's actually completely irrelevant in that scenario that there was a prior legal relationship. Not only that, for decades that we have frowned in the law of having victims of assault have to detail their sexual history, their past sexual history, and make that a determining factor as to whether or not an assault in fact happened. So look, these cases are rare. It's maybe a dozen every few years. They are not often prosecuted. And I just want to quote a letter of support that came in from the Black Caucus on this to explain why we're doing it, because I think they hit the nail on the head. There is no such thing as consent when there is an imbalance of power. So again, this bill applies to people with arrest powers. Thank you, Madam Speaker.
Mr. Floor Leader, just to follow up for a second. Now, you indicated that this anti-hanky-panky provision would preclude a police officer from engaging in those types of relations during the period that the investigation was in process, correct?
Correct. During an open investigation.
But you also would agree with me, wouldn't you, that sometimes investigations last for a long time. I mean, that's been known to happen. I mean, I've watched cold cases. They go on for months and even years at times. So I think this provision that you're speaking of gives a whole new meaning to the term cold case. I mean, can you elaborate on that? I mean, did you all consider imposing some kind of time limit on the terms of the in terms of the investigative process by which these police officers would be precluded from engaging in this kind of conduct?
I mean, again, we believe that's handled by making this limited to an open investigation and then trusting our prosecutors not to bring ridiculous cases like the one you are contemplating. But again, if we leave this language in there, then it basically means anytime there's a question about consent with a law enforcement officer investigating a suspect, we just cannot have it be a matter of gray area and calls as to whether there was consent in that situation. And again, I will point to that power imbalance. We are trying to draw a line and stand here. The last thing I'll leave you with is this. I believe we're heading into a conference committee on this bill in either case.
Thank you. Thank you, Madam Speaker.
Recognizing the gentleman from Charles County.
Oh, question for floor leader.
Yes.
It's my understanding when we're talking about law enforcement agency, are we talking about? I'm worried about the agency relationship because I know the state's attorneys have what's called an agency relationship. It's one in, all in. So in this case, are we saying that the officer precluded just can't be involved in the case, or that no officer on the force or that department can be involved with the victim, the witness, or the defendant in this case?
So this specifically says it has to be a case that the law enforcement officer is conducting, supervising, or assisting with. And again, the theory here is hopefully you beg off that case if you have some sort of conflict like that. And if it was a prior one, you would know to be able to do that. And again, if you have the case here and there that slips through the cracks, we're going to trust the discretion of the prosecutors not to bring ridiculous cases like that. But in the meantime, we are not going to give every officer an out by saying there might have been past consent, if it was a vice squad, misconduct case. It just seems very problematic to do that. We would rather just draw a bright line and say, don't do this.
I just want to ensure that it is not our intent to have that agency relationship to apply to each and every person on the force.
Yeah, and it's specifically, I believe we're talking about law enforcement officers in 3101 of public safety, which is, again, arrest powers.
Thank you very much.
The gentleman from the Eastern Shore in the Annex.
Thank you, Madam Speaker. Could the floor leader rise for a question? Or 5?
Risen. Rosed.
No, I'm here. How do you enforce this?
This would likely be, it could be a complaint to the police department itself if it would go through that complaint process. We have a few cases from the last few years that have been charged under some of these sections, but again, 5, 10 over the course of years. It's not a large number that come in. And again, these are just the ones that get charged as criminal complaints. I think likely many more are coming in as complaints that don't make it into the criminal process. So, and again, even for those that do, usually they're charged alongside other offenses. So these are serious cases that are coming through the system. This is not some trivial cases that some board prosecutor sitting around trying to bring. They just are not trying to waste time like that. I really think there's not a concern here. And when we do laws, we are not in the business of writing them so that we've covered every theoretical possible scenario that could appear in a movie. It's just not going to happen.
Yeah, I mean, I think your amendment actually covers every theoretical possibility under the sun, but the question that I was asking, maybe I asked it wrongly, it's not how you enforce it, it's rather how do you prove it, right? So let me ask that question and back it up by saying that a person who violates this section is guilty of a misdemeanor and on conviction is subject to imprisonment not exceeding 3 years or a fine not exceeding $3,000. So as we're trying to pass this bill as amended, please tell me how you prove this case.
So elsewhere this session, we are expanding wiretaps for misconduct in office, for example. There are powers of the state prosecutor we're taking a look at. We are also overhauling the police complaint process and creating a few avenues where complaints of this nature may come forward. I mean, look, you could have it for any number of situations. It could be a wide-ranging look at the gun trace task force, for example, and maybe you have an officer on the radar for one reason, but while you're looking at them, you discover, wait a second, a whole bunch of these people that officer picked up seem to just have disappeared off the radar and no charges filed. What's going on? You take a closer look, and you discover that they were trading sexual favors for not getting people in trouble. I can't imagine the entire universe, but it's serious cases that are going to rise to the level where a prosecutor is going to choose to bring criminal charges against a law enforcement officer for sexual conduct. So again, I know it's funny and the title of the bill.
No, this is far from funny.
Silly.
I'm asking a very serious question, and I'm saying that someone can go to jail for 3 years, and we're passing a bill with an amendment. I'm asking, how do you prove the case? Don't you think when we're passing law that we ought to consider what we're actually passing and how it might be applied in a courtroom?
You go to court with evidence.
Okay, so that evidence, what's the evidence? It's a serious question. I'm not playing a game here.
You might have a person come forward and testify that Officer so-and-so declines to bring me in on a warrant if I agreed to do X for Officer so-and-so.
So hearsay?
It's like any other evidence that could come into court in any other investigation. There might be corroborating witnesses. There might be GPS evidence. There could be camera evidence, body cam. We don't know.
Wiretap. You mentioned
Wiretap.
That's awesome. All right, thank you.
Gentleman from Anne Arundel County in the annex.
Thank you, Madam Speaker. Would the floor leader just answer a quick question?
Yes.
So I'm just curious, like obviously a lot of things inspire us to bring amendment when we see bills. I was just out of curiosity, is there like a reason for this? What inspired that amendment to be brought forward?
So there was a group that works with people who have brought complaints of assault, sex assault, and misconduct against officers, who actually thought this clause giving the officers an out if at any point in time they could prove a prior legal relationship was problematic. And so we kicked this around in the committee for weeks, discussing the backs and the forth in this, and ultimately erred on the side of this was indeed strange language that was so unlikely to materialize in a improper case, but was so likely to be used to make the victims bring up past sexual conduct in court. It just seems, why would we create a process that guarantees that outcome for this theoretical thing that could happen, but we know is not going to happen? And in fact, we know it's not going to happen because these cases aren't coming up right now.
Thank you. Thank you, Madam Speaker.
Recognizing the gentleman from Baltimore County.
Thank you, Madam Speaker. I don't get up a lot of times, but I have to be honest with you. Would somebody explain this bill? Would you do that, Mr. Chairman, there on the speaker there? Would you do that?
Floor leader.
Please explain it.
All right, so one more time. There is an existing law that says it is not legal for a law enforcement officer to have sex with someone in their custody. We have a similar law for corrections officers. And the basic theory of this is that it is very difficult to believe that there is pure consent between two parties when one of them is in the custody of the other person under a threat of law. So what this bill does is it attempts to expand that class to other people that we think it is improper because of this power relationship. And so that includes the suspects of the investigation, the witnesses, and the victims. And again, the problem is if it's an open investigation, these are high stakes. Someone could go to jail. You cannot have witnesses trading off sexual favors so that their husband, boyfriend, or wife, or whatever doesn't get taken in or the case gets thrown. So again, while this investigation is going on, we are asking people not to do this, and we are expanding existing law, again, that is rarely used to achieve that purpose. I think it's a very reasonable request.
Well, I think you ought to be a salesman because you just talked me right out of this sale.
Madam Speaker.
Gentleman from Frederick.
I know, I'm not on Judicia anymore. I'm allowed to stand up. Okay. So last year, I actually co-sponsored this legislation. I'm a big fan of the sponsor. And look, it's good policy to prevent a conflict where you have a law enforcement officer that is in some sort of sexual situation with somebody who's in one of these, a victim, a witness, a suspect, etc. What has changed this year is this amendment, and I'll just put it out there. The concern that I would have, and maybe the floor leader could answer, if you're the chief of police or a sheriff in a county, are you technically supervising all police activity in that county?
No.
Okay, that's good. I mean, is that defined somewhere?
I mean, in Montgomery County, we've got Tacoma Park Police Department, we've got municipal departments, we've got a Parks Police Department, we've got college police departments. We have HOAs in Maryland that have police departments.
So in Frederick County, for example, we have a sheriff, and then we have 12 municipalities. So outside those municipalities, I think it would be fair to say the sheriff would be supervising all of the remaining area. My concern would be this: if the sheriff's spouse was a victim, a witness, or a suspect in any sort of event in the county, could that put the chief law enforcement officer in a predicament? I mean, it's a fair question. Outside of that, I support the bill. And I think that's why you saw a bunch of people dissenting, because last year we all supported it unanimously. This year there's concerns. And
I understand, believe me, we wrestled with it. Since the time we last took a look at this bill, advocates came forward to describe actual cases they had that they were concerned would be altered by the language we put in. So we took another look at it, and we just came to, again, as we balanced the concerns, the likelihood that my chair is going to bring the case in the circumstances you described is so unlikely. But again, the likelihood that a vice squad officer who's being investigated for coercing all of his or her suspects into favors, being able to say, well, this is just something we did before and therefore get off, that's much more problematic and much more likely to happen.
I appreciate the questions. I'd love to support the bill. The amendment is tough. So thank you.
Gentleman from Baltimore County in the annex.
Thank you, Madam Speaker. Floor Leader, 3 quick questions for you. First of all, my understanding is with the language as it's been amended, what this says is that a law enforcement officer is not permitted to have sex with a witness. Is that correct?
Correct.
Okay. And if a law enforcement officer was having sex with a witness, even though they were having they had a prior legal engagement a couple years ago, but right now they're in the middle of an investigation, and this is a witness, and he's an investigating officer, and he's having sex with or she's having sex with him, or he's having sex with her, whatever it is, would you consider that to be perhaps a conflict of interest that may jeopardize both the investigation and the prosecution?
He or she better get off the case.
Okay. And do you think that the defense team would probably use that as a way of getting perhaps a drug dealer or a rapist or some other type of perhaps a potential felon off because of a conflict of interest that shouldn't be happening?
It's high stakes, as you suggest.
Okay. So basically what we're doing is we're saying if you behave yourselves by not having sex while the investigation is ongoing, that none of this would happen. And so we're just putting it in law so that we make sure that everybody behaves themselves. Is that basically what this law is doing?
I think it'll help the departments make more clear and firm policies with enforcement, yes.
Thank you.
Is there any further debate? Hearing none, the bill is ordered printed for third reading. Special order calendar number 25. Clerk will read the bill.
House Bill 125, Public Institutions of Higher Education, Student Athletes, Jordan McNair Safe and Fair Play Act. Favor report is amended, adopted.
Recognizing the floor leader. Oh, excuse me. The maker of the motion is the gentleman from Prince George's in the annex.
Thank you, Madam Speaker. Good afternoon, everybody. Will the floor leader rise for a couple of questions?
Yeah, no, I don't. Listen, you and I appreciate we had a great conversation in the annex where we went through about a dozen questions. I came over here, we did about half a dozen yesterday.
Yeah.
At the end of that, we went through and you asked for a special order, which was the second special order, which is not our standard procedure here. So I know you have an amendment. I appreciate you sharing that amendment with me, and I think we can hear the amendment. So thank you, sir.
So you will not answer a couple of questions? I got more questions in terms of doing the research on this.
Does the gentleman have an amendment?
Possibly. I do have one at the desk if I'm going to offer it, but depending on the answers. But why not? Let's do it. I'm in my wheelhouse. Amendment offered at the desk is 323921.
Amendment number 1.
What this amendment does, and let me start off by saying I love what this bill does for the safety of student athletes in the state of America. The McNair family suffered plenty, and we need to make sure we do everything in our power that that does not happen again. The part of the bill which concerns me is dealing with the name, image, and likeness. And the amendment I have will strike that language from the bill, and I'll explain why. And one of my colleagues knows this amendment does not make this pay for college athletes retroactive. Even I thought about that because I would have got a couple checks, but that's all right. But the reason why it concerns me is sometimes when you're trying to do right by players and athletes and individuals, you can end up doing more harm than good. This bill was introduced similarly in California, but there have been so many differences out there. There have been so many differences in different states. So my question was going to be, what's our bill like? Are we following the model of California? Are we following the model of Nebraska? Are we going to allow a student athlete to get paid for his autograph? Or are we going to say you cannot get paid for your autograph? Are we going to allow apparel companies to get involved? Like some states do, and other states say apparel companies can't. We've got a pretty large apparel company here in the state of Maryland. And looking at it, what I've noticed is a number of states, the ball is moving, have decided to take their time. There's going to be a huge, huge arms race in recruiting for college athletes. There is a major case that's taking place that the NCAA is going to vote on this March 31st of this year. I asked the floor leader, had you spoken to a president of a university in the state of Maryland that will be voting? The answer was no. Well, I spoke to them, and they asked to wait. I've also talked to coaches. I don't know if the sponsors talk to coaches. And the coaches are the ones that are going to be affected. I've talked to athletic directors. We've got 3 systems here in the state of Maryland. And there's also legislation on Capitol Hill that is going to address this. Bipartisan, by the way. Completely bipartisan. We know something needs to be done. So on Capitol Hill, you've got legislation. You don't have the big states that live and die and breed college football with this legislation yet. Talking like states like Alabama, Georgia, Louisiana. It's a big business there. And you know why they're waiting? Because they hope that other states jump out there early so they can come with a better product. And what we may be doing is harming our student athletes by restricting their earnings in ways that they should not have to do. If the bill comes out and it's the right way to do it, I would love to be on the bill, would co-sponsor the bill, and absolutely I believe that it's time that we take care of our student athletes. Being a former student athlete myself, this is long overdue. However, I cannot sit here and watch us make a mistake when we're trying to do the right thing, but there may be some naivety to it. And because of my line of work, I deal with college sports 9 months out of the year when I'm not here. So what I'm saying is, let's not put the cart ahead of the horse. College sports is big business, huge business. We must do this right. Let's talk to student athletes. Let's talk to coaches. What's going to happen when the agents get involved?
Madam Speaker.
I talked to my agent, and my agent is saying,
We're on second reader, Madam Speaker. This sounds like third reader debate. Is there an amendment?
This is my reason for offering the amendment to the bill, which is striking the language, which is all I've talked about. But I told you I love the safety of the bill, but the name, image, and likeness. So what this does is strikes that so that we can move forward at a later date, which is what I'm saying, and we do it right. I move forward with my amendment.
Floor leader.
Yeah, thank you, Madam Speaker. Listen, I'm very happy that the gentleman's called a couple coaches. That's good. But this committee has not entered into this willy-nilly. We've had this bill for 3 years in our committee. We sent this bill to the Department of Legislative Services summer study last year to consider this bill in depth. The gentleman says, do we do this like California or Nebraska, or who are we doing it like? As though this committee is just going to throw a bill out without having considered what other states have done. Quite to the contrary. This bill is modeled based on our summer study after the California and Nebraska bill. States that are going online, by the way, the same year that we amended this bill to go online. All right, so this committee's done its research. There's no one opposed to this bill. No, the only people that showed up to oppose the bill were our universities. And guess what? They now support the bill. They had actually concerns with the portion of the bill that the gentleman's not amending. They are actually supportive of the name, image, and likeness support portion of this bill. And why should they be supportive of that? Why should any of us support that? Because it's fundamental to who we are, right? Who controls your name, your image, your likeness? You've worked hard. You've built a great reputation. You've become outstanding at your craft. And we're going to have a government or a bureaucracy tell you what you can do with your name? That is fundamentally un-American. That is not who we are. These college athletes deserve to control their name, image, and likeness. The universities in our state support this. This bill passed this committee unanimously. I urge you to reject this amendment. This is a good thing for our athletes who showed up to the hearing in support of the bill. This is a good thing for our universities. It's a good thing for our state. Thank you.
Madam Speaker.
On the amendment.
Yes. On this one, so it goes back to the question I wanted to know to make sure that we're right. So if we're modeling California, how many states currently have passed this NIL legislation?
Well, currently, California, Nebraska, 5 states have passed it. There are 30 states considering it this legislative session, so there are probably a bunch of me's out there right now saying that there are 5 states and we'd be the 6th. Because
on the amendment, that being said, if this legislation passed 2 to 3 years ago, there is a landmark NCAA meeting coming up, and there's also the type of legislation on Capitol Hill. What is the rush? Why is it just 6 states out of 50? Why are we rushing? We should not rush. We should let due process happen. You can do more harm than good. You can risk student athlete eligibility by being in such a rush. When the right thing to do is let's see what the NCAA comes up with on March 31st. Let's see what happens with the Supreme Court. And you've got the bill, you put a line on there for it's going to be enacted in 2023 or 24. But what I'm saying is by putting something in place now, in law now, other states, Pennsylvania touches us, Penn State University, Virginia touches us. They're right there across the river from us. Why put us in a position where we're showing our hand and losing the leverage we may have in recruiting wars, which this is all about, because I don't know why.
Well,
we have time, and I've told you, once the time is right, I will come out 100%, work with you on it, support it, do it, because that would be the right thing to do it at the right time. But let's not put the cart ahead of the horse. I urge this body to use common sense on both sides of the aisle and say, this part of the bill we can remove. That's what my amendment does.
Floor leader.
Thank you, Madam Speaker. Listen, this body should understand that this committee is aware of the NCAA meeting. We know about it. We've been studying this bill. This isn't news. The gentleman's not delivering news to our committee. Actually, in fact, the NCAA was supposed to meet in January to deal with this issue, and they did not. They punted it again. The court is going to deal with this at the Supreme Court level this summer. Fine, but they've been dealing with these issues since 1984, and they have not resolved them. Do you know what is getting the NCAA to move forward on this? Do you know why the NCAA is doing this? Because states like California and Nebraska and Maryland are moving forward. That is how you get the NCAA to stop punting the issue from January and on and deal with this important issue for our college athletes. So we're aware of this, good sir. I appreciate you bringing it up. This is actually the very reason for the bill. We need to continue to put pressure on the NCAA to do the right thing by our college athletes and come up with a plan. Thank you.
Question before the House is the adoption of the amendment. All in favor signify by saying aye. Aye. Opposed? No. The noes have it. Amendment fails. Hearing none, the bill is now ordered printed for third reading. Special order calendar number 30. Clerk will read the first bill.
House Bill 48, criminal procedure, registered sex offenders, entry onto school property. Favor report is amended, adopted.
I need the, Sylvia, I need a favorable report.
Who's that? The maker of the motion is the gentleman from the Eastern Shore in the annex.
Madam Speaker, I've talked to the sponsor of the bill, and my questions have been answered.
Any other questions on to the bill or to its title? Hearing none, the bill is ordered printed for third reading.
449?
Special order calendar number 28. Clerk will read the bill.
House Bill 449, Family Law, Marriage, Licenses, and Records. Favorable report adopted.
The question before the House. Oh, excuse me. Oh, okay. The maker of the motion is the gentleman from Western Maryland in the annex.
Hello, Madam Speaker and Assembly. This morning when we asked for the special order, it was requested for Tuesday. So I wonder if we can just hold it until Tuesday. It was for the purposes of questions, which I don't have answered. Maybe the floor leader
If it's
could
for
answer them.
purposes of questions, you can ask them right now. If it's purposes of something else, that's different.
Very good. I could go ahead and ask a question now.
Great.
And then perhaps hold it for an amendment if it's appropriate.
If you don't have an amendment now,
Well, it is a matter of record, is it not, that it was specific to hold this till Tuesday? It wasn't just can we have a special order. It was a special order to Tuesday was the request, and that request was granted.
go ahead and ask your questions. Let's go.
Thank you, Mr. Floor Leader. The question is, this has to do with marriage certificates, and the question is, right now, what are the clerk of courses using when they do issue a marriage certificate? What are the terms? Is it person A, person B? Is it husband, wife? What are they using?
Some places are using party A, party 1 and party 2. Some places are still using husband and wife. This legislation would change it to just party 1 and party 2.
Okay. So it's not consistent across the state. It's up to each county, it sounds like.
I think that this area of the law has been changing, and so this would make it consistent everywhere across the state.
Very good. I guess before we change about 400 years of precedent on these certificates, I would like to go ahead and do an amendment. So if I could hold it till Tuesday, as was initially requested, I would appreciate that.
That's fine. Thank you.
Thank you, Floor Leader.
So, question for the House to special order HB 449 and to the appropriate hour on Tuesday. All in favor signify by saying aye. Opposed, no. The ayes have it. The bill has been special ordered. Special order calendar number 26. The clerk will read the bill.
House Bill 655, Local Government, County Commissioner Elections, District Voting. Favorable report is amended, adopted. Amendment number 1.
Maker of the motion, the gentleman.
Madam Speaker.
No. The gentleman from Western Maryland.
Thank you, Madam Speaker. I would request that I be able to press this motion and be able to make some further explanation as to why we think it's really critically important that you leave the system as it is for Garrett County. In Garrett County, we have three county commissioners, and as I explained yesterday, each commissioner has to live in a specific district, the 3 districts. But in the primary and in the general election, they have to stand for a vote at large. This bill would mean that each one of those districts, if it passes, only the people in each one of those commissioner districts would be able to vote for the people in those districts, and there would not be a large vote. In Garrett County, We feel that the current system for electing commissioners is already fair, equitable, and represents the unique needs of our community. In our system, one commissioner, as I explained, must reside in each one of those 3 districts. Garrett County does not have the diverse demographic makeup of other counties that might benefit from district voting. You know, the population in Garrett County is only 30,000 people. Of those 30,000 people in Garrett County, 96.89% are white. There are 250 Afro-Americans, or only 0.86% of the population. So I think one of the things that was concerned, and one of the reasons for doing this, was to make sure that there was equity among the races in being able to elect someone. In Garrett County, just to show that we have very few Afro-Americans, but in the town of Oakland, Oakland has a mayor and town council. Recently, there was an election when an Afro-American ran for office in Oakland. Oakland has 2,000 plus people. And in that election, the Afro-American lady won over a long-term incumbent who was a retired military person and was very, very active in the community, serving the Lions Club and everything else. So I just make this point to show you that this clearly shows that we're not racially biased or anti any race in Garrett County as far as when we hold our elections. And so I think that in itself should not be a reason for this body to change the way we hold our elections. Just to further explain, as I did yesterday, I'm the only delegate that represents Garrett County. Garrett County cannot change their laws unless they come to the Maryland General Assembly. We have to come to the Maryland General Assembly, and the only way the commissioners in the county has to come to the Maryland General Assembly to change their laws. And the only way they can do that is through one of their legislative representatives. We have 2, Senator George Edwards and myself. We meet every year with the county commissioners prior to session in a public session in the commissioner's office to have the commissioners explain to us what it is that their request for any laws that they would like to change in the county. Then Senator Edwards and I then determine when we come down here which one of those bills and how we're going to do that. And generally, we usually always accept the request from the county commissioners to change their law. So what I'm asking you and asking this body is to leave us alone in Garrett County to determine the way we do the elections. The commissioners haven't requested this to be changed. There hasn't been any request from anyone in the county to us to change the way we've been doing it. I was a county commissioner and went through this process, and it works very well because the way it is now, as I explained yesterday, that anyone running to be a county commissioner, by the way we do it, has to campaign in the whole county. So we're such a diverse county that this really means that the people get to understand and know whoever it is that's running for office. So with that, Madam Speaker, I move this amendment. Thank you, Madam Speaker.
Subcommittee Chair.
Thank you so much, Madam Speaker. Colleagues, we have been discussing this legislation on second reader for 3 days now. And I wish to just remind the body what the purpose is of this bill. The purpose of this bill is fair representation for all, to ensure that in-district voting is in-district voting, so that the voters of Garrett County in District 3 don't get to determine the election in District 1. This legislation is not even about any particular jurisdiction. It is about fair representation for all. And what we are doing is preparing ourselves to make a historic vote to ensure that we root out this system that is rooted in suppression. So that is why it's critical that we not adopt this amendment that literally says this section does not apply to Garrett County. Fair representation applies to all. I urge the body to reject this amendment.
Madam Speaker, the young lady, Madam Speaker.
Everybody sit down right now. Sit down. Sit down.
My character was just impugned, and I don't appreciate it.
Sit down, please.
Excuse me?
Please sit down. Who was the first one up? The gentleman from Caroline County.
Thank you, Madam Speaker. On this bill, I do have a question for the floor leader. On the amendment. A question on the amendment for the floor leader. Thank you.
Yes.
All right, so you talked about the purpose of this bill is for racial fairness and equity all across the line. Now, my question for you is I'm looking at the demographics in Garrett County. 96.5% of the population in Garrett County is white. 0.776% is black or African American, non-Hispanic, and 0.565% is Hispanic. So, given if we don't accept the amendment, which I'm assuming that you're not going to do, how's this going to help your cause? What I don't understand is this bill isn't really going to change anything in Garrett County at all, just because there's already not a large racial diversity in that county. Is this going to help your cause or not help your cause by either accepting or not accepting this amendment?
Delegate, as I mentioned, this legislation is not about any particular jurisdiction. It's to ensure fair representation for every jurisdiction. And so by removing Garrett County, that does not achieve the goals of this legislation. We want to ensure, once again, that in-district voting is in-district voting.
So will you agree, though, that by requiring this legislation in Garrett County that it won't change much? Will you agree to that?
I haven't looked at the numbers specific
I just gave you the numbers,
to Garrett County, but what it will change is for the voters that they get to elect the people in their district and they get to choose. That's the difference. That's the major difference in why we are moving forward with this legislation.
All right, we're talking about fairness. Okay, there's not a big difference in the demographic population in Garrett County. And then we're talking about fairness. Do we think it's fair or unfair that we're going to take away local autonomy and let the voters in Garrett County decide for themselves, how they want their election districts to be represented and how they're going to vote on those?
I think that it's our duty and obligation, as I mentioned before, as a legislature to ensure this voting rights legislation passes. I think that it's our duty as a legislature and our obligation to move forward with fair representation. So I don't agree.
Okay, so on the amendment, I do agree that maybe in some cases that this bill will make voter representation more fair. But here we go again. One size does not fit all in Maryland. And I've given you all the statistics here, the demographic statistics in Garrett County. More than 95% of the population in Garrett County is white. Less than 1% are minorities. This bill will do nothing to accomplish what the mission is and what the goal is in this bill. And so now what we're going to do is we're going to turn our back on the delegation in Garrett County. We're going to turn our back on the people in Garrett County and pass a bill and more than likely not vote on an amendment that's going to make it fair for the voters in Garrett County. I don't think so. We keep saying this over and over again. One size doesn't fit all in Maryland, but here we are as a General Assembly. We're smarter than the people who are back home. So thank you, Madam Speaker.
Majority Leader.
Madam Speaker. Thank you, Madam Speaker. And thank you to my colleagues. I appreciate the debate on this. I want to say, and I think we're going to have this plenty of times this session, we're going to have some difficult conversations this session. And they will at times touch on, for example, issues of race. And those can be difficult conversations to have. And that's okay. And I think all of us need to make sure that we're keeping in mind that everybody in this chamber and everybody in the annex is doing their best to make decisions on bills in good faith. The way I read the debate on this amendment, and frankly on the underlying bill, is that members of my party believe that the type of elections we're discussing here are fundamentally undemocratic and unrepresentative, right? That for somebody in another district to tell me who represents me in my district, that's undemocratic. And, you know, the conversation, I think some of the offense that's popped up on the floor has to do with the suggestion that this type of voting has been used in instances to suppress minority votes. So in having that discussion, I want to make clear to everyone in this body that nobody is impugning the motives or suggesting anything about the beliefs of anybody in this body. Right? To criticize a system is not to criticize individuals. To say that this has been used to negative effect elsewhere is not necessarily to say that it's the intent of a particular county to use it that way here. So for me, what this issue is really about, fundamentally, is a question of local control, right? Local courtesy. And our party, I think the majority of our members, of the majority on the floor, believe that this type of voting is undemocratic and should be banned across the state. And members of the minority party believe that their locality should have the ability to make that decision. And that's a fair disagreement, right? Like, local courtesy is not absolute. I'm the majority leader. I've got local bills that don't pass every year, right? That's a fair conversation to have. But I would encourage all of us to approach this debate and all the other debates we have on what are going to be some difficult issues this session with the assumption that members on the other side are acting in good faith, out of honest belief, right? That's what this is about. I would join with the floor leader in asking folks to reject this amendment because I personally believe that this type of voting is not a type of voting we should use in the state of Maryland. Thank you, Madam Speaker.
Madam Speaker.
Madam Speaker.
The gentleman from Montgomery County and the Annex.
Thank you, Madam Speaker. I have a quick question for the floor leader.
Yes, hello.
Thank you. This bill seems very straightforward, and I just have a quick question, just so that we are not just reiterating but clarifying here. If I were to live, say, in District 1, should I be deciding who represents and what kind of a representation is appropriate for another district?
No, you should not be able to do that, and this amendment exempts Garrett County.
Well, I'm old enough to remember that Republicans were complaining about people coming from outside of certain states to vote in some states during the presidential election. And if we can understand that, we can understand why it's important for people who live in certain communities or districts to determine who represent them and nobody outside of that district. And I appreciate that clarification, Madam Floor Leader. And I'd just like to say, whoever that member was that referred to the good delegate from District 20, who was duly elected by her representatives as young
Madam
lady,
Speaker, are we
was
on the amendment?
Inappropriate and out of line.
Madam Speaker, I don't believe
do
we're
not
on the
have an
amendment.
But that was inappropriate and out
Gentlemen,
of line.
on
whoever
the
that was.
amendment, please. On the amendment.
Madam Speaker.
Gentlelady from Carroll.
Thank you, Madam Speaker. This has been an interesting debate, and what we're asking you to do is to understand what it's like in our counties. I know you come from this from a certain point of view. Some of our counties are very large, and we have a small population. Garrett County is one of them. I'm speaking in favor of this amendment. I think the good gentleman from Garrett County has explained it. They have a very large county, and they have 3 county commissioners, and they want to make sure all of the whole area is relevant. And that's why they made districts up, to make sure that someone lived in those districts, so those districts that were rural would be relevant. If you do this, we might end up with 3 commissioners, all from Oakland, where everybody lives and where the population center is. And the smaller counties want to make sure that there is geographic diversity. They don't have the need for racial diversity because they don't have that population. They want geographic diversity to make sure that all areas have someone that's looking out for them. That's true with a lot of the counties. And the biggest issue I have with this bill is you've taken away local control. People have determined how they want their counties to be organized over years, hundreds of years. In our county, in Carroll County, we had 3 commissioners at large for many, many years. And we had discussions on charter government, we had discussions on code home rule, we had discussions on districts. So we went to the voters a number of times, and they decided they wanted districts. And our districts are just as you are trying to get the rest of the counties. We are elected by district. But the opposite thing happened in our county. We had a wonderful black county commissioner. We loved him. He was elected at large. We have school board members that are elected at large, and we've had black school board members for years, elected top vote getter in our county that has similar demographics to Garrett County. Unfortunately, when we went to districts, our county-wide elected county commissioner lost when we went to the districts. So if you look, it doesn't always work out how you think it's going to work out. But the bottom line is in Carroll County, we made the decision, our voters decided how we wanted to run our elections, and we don't have a problem, the problems that you're describing. So this is about local control and people deciding in their own districts how they want to operate. It went to the voters. If St. Mary's County wants this change, take it to their voters and vote on the change. But to come here and have someone tell us what to do from other counties that are very different from us, way different, it's just, we're going down a slippery slope, and it's very frustrating to the minority who live in these different kinds of counties, and you won't appreciate that we are different. So I rise to support this gentleman's amendment. Thank you very much.
Thank you, Madam Speaker.
Gentlelady from Howard County and the Annex.
Thank you, Madam Speaker. I hadn't intended to speak on this bill until I was listening to the majority leader, and he said something that made me curious to see if he can tell me. He said it's undemocratic for people in a district to have people outside that district tell them who should be elected. Isn't that true that we and other counties would be undemocratic for us to tell a different county how they should be elected? It seems to me that that's the same exact parallel. Got people outside of the county telling the counties what to do. So why is it any different that people in a district would be undemocratic to have other members of their own county tell them voting on the same people? Just doesn't make sense. I'd be happy to have an explanation or a...
Subcommittee Chair.
Delegate, thank you for the question. I think that when it comes to elections in our jurisdictions, there are a multitude of ways that the state determines the elections. This idea around local rights when it comes to elections in a lot of ways is actually false. We determine the dates of the elections. We determine in many ways how they are conducted at the state level. So in terms of your comments in regards to, the state stepping in and this being an overreach and comparing that to this legislation, I don't think that that is the case. The way that our elections are run is something that is determined by the state in so many different ways. So once again, I urge the body to reject this amendment and that we keep all of the districts that are currently, all the jurisdictions that are currently listed in the bill, within the bill, because this is about fair representation for all.
Madam Speaker.
Gentleman from Calvert.
Thank you, Madam Speaker. Might surprise you, but half of what the majority leader said I actually agree with, and that's rare. And it's the part where we do need to have difficult conversations, and we need to have them civilly. And so I rise to support this amendment. And I support this amendment because I do believe, of course, in local privilege. The County of Garrett has had incredibly hard times It's depopulating. Think about that. And here we are in Annapolis. A lot of what we do is responsible for it depopulating because it is near other states where people can move to. Not a great situation to be in. It's a tiny county in terms of population. And so when people run, and they run county-wide, it's incredibly difficult as it is, obviously, because of the mountains and so forth. But you get to know people. You get to know all different kinds of communities. And you vote for the commissioners, of course, county-wide. It makes perfect sense. It's a small community, right? Kind of everybody knows everybody else. This is very relatable because it's similar to my county. Super relatable. And all they're asking for is the right to make their own decisions. And if there were a problem, if there were an issue that required that difficult conversation, then I would ask someone in the body to specify what it is in Garrett County, because that's what we're talking about now is Garrett County. And I haven't heard it. I also watched the hearing and I didn't hear any testimony. None about Garrett County. Also didn't hear any about mine either, but that's a different story that will come later. And so for all those reasons, it just makes sense. Let's have the difficult conversations. I agree with the majority leader. Let's do it civilly. But let's do it and be honest about them, about where there may be problems and where there aren't. Garrett isn't one of them. Thank you, Madam Speaker.
Madam Speaker.
The gentleman from Frederick.
Thank you, Madam Speaker, and I rise to support the amendment as well. My good friend from Garrett County has a very fair amendment, and I just want to point out that the amendment dispels the myth that somehow Garrett County elections or these other similar elections are somehow unfair. Right now in Garrett County, all minorities can vote for a candidate anywhere in this three-commissioner race that were to run. But under this amendment, you're going to disenfranchise minorities from voting for a minority candidate that wishes to run. So I just want to point that out. Thank you.
On the amendment.
Madam Speaker, can I just make one final comment, if I may?
The amendment.
I'd like to thank this body for the debate and the opportunity to offer this amendment. You know, I've been here for quite a while, and there have been a lot of bills offered by counties where they came in with just their county request to change the way they govern, to change the way that they handle the different offices in their county, and they've been given local courtesy for those different counties. But they haven't been, I haven't seen any case where they have actually someone has came in and tried to force a county to change the way they select their people when that county is totally opposed and have not made those requests. So Garrett County doesn't want this. The representatives from Garrett County, being myself and Senator Edwards, don't want this, and we're the only two legislators here that represent the whole county, and we don't even represent just Garrett County. We represent part of others. So I would ask this body to support this amendment. So, Madam Speaker, I move the amendment.
The question before the House is the adoption of the amendment. All in favor signify by saying aye. Opposed, no.
Roll call, Madam Speaker.
Roll call.
Madam Speaker.
Kirk will take the call. Clerk will take the call. The amendment fails. Any other amendments?
Madam Speaker.
Floor leader. The subcommittee chair, sorry.
Thank you, Madam Speaker. I have an amendment at the desk. It is amendment number 783-724/1.
Amendment number 1.
So much be considered the reading of the amendment.
So ordered.
Thank you, Madam Speaker. Under this amendment, in counties in which members of the county board are elected from individual districts, the election of a member of the county board to represent a specific district shall be decided by a plurality of the voters cast within that district. I move the amendment.
The question for the House is the adoption of the amendment. All in favor signify by saying aye. Maybe I should say that again. The question before the House, I didn't hear anything. The question before the House is the adoption of the amendment. All in favor signify by saying aye. Opposed, no. The One second. Where? The gentleman from Anne Arundel in the annex. On the amendment.
Thank you, Madam Speaker. Can I just want to get clarification on the amendment? Can you just repeat quickly what it does? And is this the same amendment that we heard yesterday, or is it different?
Sure. Thank you so much, Delegate. What this amendment does is it brings our local school boards in line with the principles of the bill, meaning that voters in district, in terms of school boards, get to determine their school board representation.
So didn't we have, if my memory serves me correctly, is this the same amendment we had yesterday?
Thank you so much, Delegate. As I mentioned yesterday, the committee and the subcommittee didn't have an opportunity when it was presented on the floor to be able to discuss the issue at hand that amendment referred to. We were able to discuss this both in subcommittee and in the committee, and now I have brought the amendment.
Okay, I was just confused because I know a lot of people stood up yesterday and they were arguing against it. I just wanted to see what the change of heart. Thank you, I appreciate it.
Madam Speaker.
Gentleman from St. Mary's.
Thank you, Madam Speaker. I got an amendment at the desk.
Amendment. We were still on this amendment.
I thought you adopted that. I'm sorry.
Madam Speaker, question on the amendment.
Gentlelady from Carroll.
I see we're adding school boards to this, and we didn't have this discussion yesterday. It's like sort of like the Wild West, just things rolling along really fast. Just a question, how many municipalities operate like this and have districts? Now that we've included school boards and commissioners, we exempted a charter government, so how many municipalities are in the same posture that elect by district?
The jurisdictions that would be impacted by this bill include Cecil County, Calvert County, Garrett.
That wasn't my question.
Montgomery.
My question had to do with municipalities. How many municipalities in Maryland of the 150 some elect by district in their municipalities? I mean, if this is a problem, I mean, I'm trying to figure out if you really looked at the whole problem, or we're just sort of going on the fly here.
This bill doesn't deal with municipalities, so that's outside of this legislation.
Well, it didn't deal with school boards until yesterday. So I'm just asking the question today about municipal. Now that we're thinking about it.
And as I mentioned, Delegate, we took that back to our committee and we discussed school boards. So this bill deals with county commissioners, and under the amendment will also include school boards. That's it.
Will the floor leader yield?
Thank you.
Subcommittee Chair. Madam Speaker,
Chair of the committee.
the question was brought up about the municipal officials in all of our municipalities. I believe they have their elections in some cases this year because of the off-year elections. So this would be a more appropriate bill to take up in an even year to not impact them because the elections are coming up in some cases. Thank you.
Gentleman from St. Mary's.
Madam Speaker, I want to thank the committee chair and the floor leader for working with us on that amendment I presented yesterday, and I want to thank them for considering it and adopting it. You know, this bill is about fairness. It should be applied across the board, and I believe it is applied more fairly now, even though our districts do seem to have some issues, and we have further amendments to address that. Thank you, Madam Speaker.
All in favor of the amendment signify by saying aye. Opposed, no. The amendment has been adopted. Any other amendments to the bill or to its title?
Madam Speaker, an amendment at the desk.
Gentleman from St. Mary's.
Thank you, Madam Speaker. Amendment at the desk 653524/1.
Amendment number 1.
So be considered a reading of that amendment.
So ordered.
I'm so used to saying good morning to you all. Good evening. We're now on day 3 of what should have probably been a local bill. But I do want to thank the committee chair, and I especially want to thank the floor leader. This has been a spirited debate, and she's done a good job defending this bill. And I even want to thank the bill sponsor. I called him last night and tried to work out this amendment with him and had a pretty pleasant conversation with him. And after yesterday's heated debate, the majority leader came back, and we had a pretty decent conversation too. So I want to thank him for his kind words. My disagreement really on this bill is how it was presented. And really, I mean, we saw that right from the vote today. You know, everybody wants to drive this to, like, these counties are disenfranchising minority voters. And then the majority leader spoke to that just a few minutes ago. Here's the thing. You can have a system that's being misused, and then you can have a system that's not being misused. And us down here in St. Mary's County is really affected by that. We look next door at Charles County, and Charles County has the exact same system and has a minority majority on their board of county commissioners. So the reason why we split our county up in district has to do more with our geographical, where we're located in the state. If you drive to St. Mary's County, you go from Charlotte Hall to Point Lookout, it's like 60 miles. And the county's never more than probably 15 miles wide at its biggest point. It's split up like that to ensure geographical diversity for our county commissioners, and it's been that way for 170 years. You know, and seeing like the bill presented, like and like you're violating the Civil Rights Act, that's crazy. Because currently we have an African American female serving on our board of county commissioners that was elected countywide. She's been there for 24 years. 10 years ago, the county wanted to have an African American congressman. Charles Lawler beat Steny Hoyer in that district by double digits. You get back a little bit further, Michael Steele beat Ben Cardin in that district by double digits. This isn't about skin color. It's about local courtesy and what's going on here. This is why the minority party is so frustrated over this right now. You know, I mean, it's a false narrative onto our counties. They're pushing it. You know, just because we have at-large voting in our district doesn't mean it's misused. There's not a single evidence of any type of racial discrimination, period. But somehow we're getting grouped in. It's not right. What are we doing here? Look, we had one delegate sponsor this bill and about 20 activists come down from St. Mary's County on a chain email. Most of them have ties to the Democratic Club, Democratic Central Committee, complaining about one district in St. Mary's, District 4, that they didn't run a candidate in 2018. They didn't run a candidate in 2014. And they're sitting there saying, well, we're disadvantaged. You didn't try. How do you know this? Are we just going to make an assumption that white people vote for white people and black people vote for black people? I can't think of anything more terrible than that. And just because we come here and you have the numbers, you're going to jam this onto the rural areas, I don't think that's right. That's not right. We're talking about fairness. That's not right. This isn't democracy, what we're doing here. This is tyranny. And we need to get back to democracy. And that's what this amendment is. I don't think we can have any more support for democracy. And then when politicians can't figure it out, that we just turn it back to the people and let them decide. This amendment is about a voter referendum, puts this bill on the ballot in St. Mary's County in the 2022 election to let the people decide what type of voting they want. Maybe I'm wrong. Maybe I'm wrong, but I don't think I am. And I don't think you can go wrong with having the people decide. So with that, Madam Speaker, I move that amendment. Thank you.
Floor leader. Gentleman from Charles.
Thank you, colleagues. I rise in opposition to this amendment. And it's listening. I understand the maker's frustration. You know, we painted some people through Twitter and others through voice. Counties like Calvert that elected an openly gay judge and didn't even run anybody against them. With minorities, the minority, African Americans definitely are not the minority or majority in Calvert County. I understand the frustration because they were still able to elect African Americans to their board. And so for all my colleagues that wish to call this a racial success, please don't. Some of these counties don't need help. However, Charles County, where I live, for years we fought for this kind of representation. When we were the minority, African Americans fought their tails off just to get a voice, just to get one district. And white Republicans, when they were in charge, they said no. But don't smile too much, because when white Democrats were in charge, they also said no. And now we are finally in charge, and we have to give up a district. But see, just because your demographic changed, that doesn't mean your values change. So if you believe in one man, one vote, you always believe in it. I can't say that I trust the people, because the people in Charles County 20 and 30 years ago would have said no. African Americans don't get a voice or a district. White Democrats and white Republicans would have said no. If you believe in one vote, if you believe in representation and a voice, then I ask you to oppose this amendment. We have a duty, and it's to make sure we help these individuals. Again, this is not about race. I agree with you. I agree, that was a mistake to bring it up. It's about your values and how we're going to be represented as a state and as counties. I ask you to reject this amendment.
On the floor leader.
Madam Speaker, I just want to associate myself with the comments from the gentleman from Charles County. He said it. Let's reject this amendment. Thank you.
Questions? On the amendment, all in favor signify by saying aye. Oppose?
Roll call, Madam Speaker.
Roll call.
Madam Speaker?
Clerk will take the call. The amendment fails. Any other amendments to this bill or to its title?
Yes, Madam Speaker.
Recognizing gentleman from Calvert.
Thank you, Madam Speaker. I do want to, if you don't mind, just make a comment about my suite mate, not my suite mate, but my seat mate from Calvert County, from Southern Calvert. He was supposed to offer a couple of amendments, and he had his second vaccination today and fell very, very ill. So I'm offering this amendment in his place. He's a former county commissioner of Calvert County and is truly a gentleman. So first up, there's a letter that I had offered that we provided from the Calvert County Commissioners that asked for the County of Calvert to not be included in this bill. And I know that with the COVID restrictions, some of them I might add with respect to the hearing restrictions of submitting testimony, whether it be written or oral, certainly seems to be somewhat onerous. And so this letter did not apparently get to the committee, and I don't doubt that it did not. And so we did provide the letter after the fact. The county said that they sent it directly, but it's a letter from the Calvert County Commissioners, which is in opposition to House Bill 655, and asked for the committee to simply reach out to them. The commissioner president who signed it in Calvert County is Buddy Hance, the former Secretary of Agriculture under Martin O'Malley. He's the president of the Calvert County Commissioners. And so, Madam Speaker, I have an amendment at the desk. It's amendment number 593626-1.
Amendment number 1.
So much be considered the reading of the amendment,
So
Madam
ordered.
Speaker. Thank you, Madam Speaker. It's a very simple amendment. It takes Calvert County, and it's a principled amendment, simply takes Calvert County out of this bill. And as you've heard us talk about local privilege, it just makes perfect sense. It's my Southern Calvert County suite mates amendment. It's a good amendment. You said, the majority leader said that he wanted to have, and that we will have, and that we should have, and I agree, difficult conversations. And I agree. In Calvert County, it was the Democrat Party that was the party of slavery in Calvert, no doubt. It was the Democrat Party that was the party of Jim Crow. That's a fact. When I moved to Calvert County, the party affiliation started to swing Republican. It was then that the first black commissioner was the head of the Calvert County Commission, and he was a Republican. His name is Mr. Reed. It was the Republican Party that was the party of inclusion, and currently still is the party of inclusion in Calvert County. Republicans took over, and we elected Commissioner Michael Moore, also black. Commissioner Wilson Perrin, kind of a household name in many parts of the state, also black. Von Zell Ward, ladies and gentlemen, we elected him the sheriff of Calvert County. Can you imagine? None of this stuff was possible under the old Democrat establishment because of what had happened in Calvert for so many years. It was the Republicans that made this happen. And then there was a judge, and I remember the Senate president, the then Senate president, came to us and said, Mark, do you support, or delegate, do you support this judge for the circuit court? I said, absolutely. Did not judge him by the way he looked. Did not judge him by other issues. And he was appointed. And then appointed again to the Court of Special Appeals. All from Calvert County. Not all things are what they seem. We have to stop judging people by the way they look and where they're from, and just assume that the election system in their counties is one that is perpetuating certain systems. Not so in Calvert County, as I just described. Not so. And I'm proud to say that I am that guy who's in large part made that happen in Calvert County. It is me, and it is the many people that came before me who moved the county to a Republican county who changed things. And I'm the guy that to this day still reaches out to all communities and knocks on all doors and goes to all churches and lives literally around the corner from the newly appointed delegate, from her parents and from her childhood home. It's where I live. I choose to live there. Didn't move there for politics, choose to live there. Finish this. I'd like to finish with this. The most robust land preservation program in the state of Maryland at the local level is Calvert County. We have the bay on one side, and we have the river on the other side. And the river meets the bay at Solomon's Island. It's beautiful, stunning county. If you Google Earth Calvert County, and you look at the sheer number of farms that are on the Patuxent River or on the inside of the county, you will see that there is so much land preserved. It's hard to believe something so close to Washington, D.C. can have so much open land. And that happened because of the Republican Party. Because ironically, another thing that is quite ironic and opposite of so many other areas, maybe not, I don't know, because I don't know the other areas in this detail. But in Calvert County, it was the Republican Party, and still is, that is the party of land preservation. I am known in Calvert County as being a land preservationist. And that means land that can't be developed. Land that has reduced taxes so that it can remain in the farming community. And that is a good thing. And that continues to this day. Those traditions continue to this day. And so, if you've seen me concerned and upset and rising and saying, I don't like my character to be impugned. It's in part because of the tweets that I see and the fact that some, and I hope to change their minds through this conversation, some are judging all counties the same and all areas the same, and that's wrong. That's identity politics. It's something we need to move away from, because Calvert County is not what it seems. It's the complete opposite of what has been presented here. And I'm so pleased to be that person to bring this voice to this body to tell you about our history. Because it is true that to this day, Marie Duffield, an operator for Steny Hoyer, I'm sure you know her. She's a very good friend. I've known her for 30 years plus, back when I lived in Charles County. Marie Duffield is an operative for Steny Hoyer, and she's a very nice person, been longtime friends, and she used to say to me, and still does, that they cannot unlock Calvert County. It's far too complicated. They can't figure out why people vote the way they do, and why they aren't opposed to each other, and why they aren't balkanized like they are in so many other places. In my opinion, if House Bill 655 were to pass, and my amendment does not pass here, Calvert County will be balkanized, and it will actually result in the opposite effect. The opposite will happen. The bad stuff will happen. And so for all those reasons, Madam Speaker, I ask for a green vote on this very reasonable amendment.
Subcommittee Chair.
Thank you, Madam Speaker, and thank you so much for Delegate for being willing to bring this amendment on behalf of the good delegates' behalf. He did share these amendments with me, and I appreciate that, and we also wish him well and that he heals quickly. On the amendment, I want to urge the body once again to reject this amendment and any attempts to remove a jurisdiction from this bill. Once again, this is a bill that is about fair representation for all. And this amendment exempts Calvert County from that. Therefore, I urge the body to reject this amendment. Thank you.
On the amendment, all in favor signify by saying aye. Opposed, no.
Roll call, Madam Speaker.
Roll call.
Madam Speaker?
Clerk will take the call. The amendment fails. Gentleman from Queen Anne's in the Annex.
Madam Speaker, I have an amendment at the desk, 903-624/1.
Amendment number 1.
Much reading an amendment. You know, I come up here similar to my colleagues, and I represent Queen Anne's County. I listened to my friend from Garrett County speak about his amendment, and we're in a similar situation only because of our size. We're about 50,000 people. And a few years back, we had a circumstance in our county where we actually thought about this bill. We decided to have a conversation in our county. I'm a previous county commissioner, and I understand what it's like to run in districts plus at large. I was the at large representative, and we take a look at it because we are a very good county. We're a very personal county. We know each other pretty well. 50,000 plus people. It's a great community. I mean, we have great schools, we have great people, we have great fun. Everything's good over there. But we took this because we had situations where somebody or a group of people felt that this was the right way to go. This bill was the right way to go. But we did it the right way. We actually sat back and said, how are we going to address this? Because we just don't want to change the rules because somebody was unhappy. So my county asked me to put in a bill to actually do a referendum and put it on the ballot. Queen Anne's County stepped up. They did that. There was a lot of time and effort spent to talk about this ballot, this referendum, if you will. People went out and actually went door to door, campaigned, and talked to people about what they think and what they need and what they feel is proper for our counties. And I looked at it and I said, okay, so I have five votes I get. Now I have 2. And we talk about how that all affects people. And in my opinion, my county actually spoke. And to watch the local courtesy, because we actually did our homework. We actually went to the people in our county and talked to them about it. We didn't sit up here and decide what was right for some group of people we don't even know. We went out and we campaigned, and they fought, and 2 groups fought over it. And the battle was won for somebody, and that battle came back. We want to stay the way we are. We like the way we vote. We like the people we get. We do have pretty fair representation in our county. Our 4 districts are represented, and everybody gets to vote for somebody in each area because that's the way we decided to do it. And all my amendment does, and I know the floor leader doesn't like this, but we did our homework. We worked hard for it. We're just asking you to please consider what we believe is right for us and let us make our own decisions. We're grown-ups. We're good people. I asked to move the amendment. I ask you to support it and remove Queen Anne County from this bill.
Subcommittee Chair.
Thank you, Madam Speaker. Once again, this is an amendment to remove a jurisdiction from this legislation, our fair representation for all legislation. I urge the body to once again reject this amendment and any amendments that seek to remove any jurisdictions from this bill.
Madam Speaker, just on the amendment, and I'll quit.
Maker of the amendment.
This is a bill that's trying to tell the little guys what to do, and it's nothing more than that. We made our choices, and for the state to take that away is just patently unfair. Thank you.
Gentleman from the Eastern Shore in the annex on the amendment.
Are we good? Okay. Thank you. I just want to rise in support of the amendment. This bill deals with a lot of areas that have little representation as far as votes, and we get elected, right? And we're supposed to go to Annapolis and represent our districts and communicate with our colleagues and share our concerns and tell our story. But you come up here and you make arguments and you push a button and you get the same result. And we're talking about a democratic process that's supposed to be pure. Look around at what's happening right now. We're ignoring our role. This amendment is perfectly reasonable. And I don't know exactly the context of everybody's district in the body, but on the shore, we represent several counties, all right? And it's usually multiple people representing separate counties. So when you want to talk about the purity of elections and the purity of the election process, just look at our House districts. 4 counties, 2 individuals, top 2 vote getters. But get this, they can't be from the same county. What purification democratic process makes that analysis? This is a perfectly reasonable amendment. I support it. I hope you all will consider some of the implications of what's going on here. The word tyranny was used. Think about that. That's serious. That is very serious. And we've had votes this year, and we've talked about one Maryland. And we keep pushing and pushing and pushing, and one Maryland gets stressed and more stressed, and eventually it breaks down. I support the amendment. I hope you will too.
Any further debate? Hearing none, the question before the House is the adoption of the amendment. All in favor signify by saying aye. Oppose?
Roll call, Madam Speaker.
Roll call.
Madam Speaker?
Clerk will take the call. The amendment fails.
Madam Speaker.
Gentleman from Calvert.
Thank you, Madam Speaker. So I do have an amendment, but first I have a couple of questions for the floor leader, if I may.
Hello.
Hey. Do we know in your county, in Montgomery, how many Republicans are elected at the local level?
None. At the local level? Well, none, but some of the races are nonpartisan.
Sure. I think it's 0, probably.
Yeah, it said none.
Okay.
Yes.
Fair enough. Thank you. Thank you. I appreciate it. That's a easy one. Softball. So, Madam Speaker, I have an amendment at the desk. It is amendment number 453627-1.
Amendment number 1.
So much be considered the reading of the amendment, Madam Speaker.
So ordered.
Thank you. So, ladies and gentlemen, if you look at the voter rolls, and we're talking about what's fair, you look at Anne Arundel County has more than 100,000 Republicans, and there are Republicans elected at the local level. In Baltimore County, there are more than 100,000 Republicans, and there are people elected who are Republican at the local level. In Montgomery County, there are more than 100,000 Republicans, and there aren't any Republicans elected at the local level. And so, this amendment is trying to correct what I think is a system of discrimination against Republicans. And I think it's important that we include equity for Republicans. And here is what it says. That under the provisions of the election law article, the Montgomery County Board of Elections, in consultation with the State Board of Elections, shall prepare and include on the ballot for the November general election of 2022 the following question. Do you favor redrawing the Montgomery County districts to guarantee that at least one county council district is composed of a majority of voters who are members of the minority party? Makes sense, right? Makes sense that what's being done to Calvert County here, especially after I offered the previous amendment, that the same apply to Montgomery County. Because apparently, diversity does not include in Montgomery County diversity of thought. There isn't diversity of thought. And it has been systematically removed because of the systems of gerrymandering and the systems of redistricting in Montgomery County. And it has led to, as a result of that groupthink in Montgomery County, it has led to some of the worst policies and embarrassing policies in the United States of America. And here is one. National news. Your county decided to shut down private schools. Think about that. The teachers union lobbied the county council and the county executive because they didn't want their schools open, so they lobbied them to shut down.
Madam Speaker, are we on whatever this
schools.
amendment is about?
We are. We're talking about diversity of thought and the need for more diversity of opinion in Montgomery County. It's right on message, Madam Speaker. I
Is
know
that in your amendment?
Sure. And so, and I appreciate that, Madam Speaker, I do. This is important. I mean, we said that we want to have difficult discussions, and I agree. And the gentleman who just stood up should welcome the difficult discussion.
This doesn't seem like a discussion, but if you're ceding your time and you want to discuss it, I'd be happy to engage on how the health officers are
Sure,
selected in each county.
Madam Speaker,
And it was the county health officer that made a health-based decision on the
Madam
schools.
Speaker, I haven't yielded the floor.
Not a single member of the county council.
Can both of you please?
Sure. Thank you, Madam Speaker.
Maker of the amendment.
I appreciate it because I did have the floor, in all fairness, and I appreciate you doing that. So, no sooner did that health officer do that than they ended up literally reversing it because it wasn't based on science. It was based on the teachers' union lobbying the county executive. So my point is this, Madam Speaker, which goes to the amendment. If there were real diversity of thought in Montgomery County as a result of having a minority party on the county council, you would have a voice in Montgomery County that actually talked about the complicated issues facing us in 2020 and now 2021. But that didn't happen, and it hasn't happened. And I find it stunning that a county is telling Calvert what it must do when it won't do it itself and is involved in nothing more than groupthink. And we have children suffering, and it's constantly on national news in Montgomery County. And it goes to this amendment. In Calvert County, we have not only diversity of party, but diversity of opinion and diversity itself in various offices. But in Montgomery County, diversity is only the way you look. As long as you think the right way, that's all that matters. Well, it's high time in Montgomery County, with more than 100,000 unrepresented Republicans, that they finally stop disenfranchising so many people and include, for the first time in my memory, diversity of opinion. Thank you, Madam Speaker.
Let me remind the members that we have until 6 p.m. and still have more work to get finished tonight. Subcommittee Chair.
Thank you, Madam Speaker. Wow. It's hard to find the words to say to respond to that. But I do find it surprising that the same delegate who stood up in offense to my general statement about a factual statement regarding the origins of legislation like this one would then stand up and impugn my county and talk about lack of diversity of thought in one of the most diverse jurisdictions in the entire country. But on the amendment, because colleagues, as a House parliamentarian, I'd like to remind us that our debate stays on topic. So on the actual amendment, I urge you to reject this amendment once again. And I urge you to reject it because the beauty of this legislation, House Bill 655, is that it doesn't target particular jurisdictions. It says that every jurisdiction that currently has in-district voting but elects them at large must now take the step to make in-district voting in-district voting. It's unfortunate that the delegate has introduced this amendment that brings in a jurisdiction, Montgomery County, that already has in-district voting, that is in-district voting at the county level. This amendment needs to be rejected because we do not need a straw poll. What we need is fair representation for all. I urge the body to reject this amendment. Thank you.
The question before the House is the adoption of the amendment. All in favor signify by saying aye. Aye. Oppose?
Roll call, Madam Speaker.
Roll call.
Madam Speaker?
Clerk will take the call. The amendment fails. If there are no other amendments, the bill is ordered printed for third reading. Special order calendar number 27. Clerk will read first bill.
House Bill 489, courts wiretapping misconduct in office. Favor report is amended and adopted.
The maker of the motion is the gentleman from the Eastern Shore in the annex.
Thank you, Speaker. I had some time to go over the bill. The state prosecutor's office was able to make contact with me, and they were able to answer my questions with jury instructions, which I found to be interesting. But for purposes of amendment, my questions have been answered. Thank you.
Okay. Question for the House is the adoption. Oh, we're on second reading. All right, the bill has been ordered printed for third reading. That ends the work at the desk. All committee bill hearings are listed on the Maryland General Assembly website. Please go home this weekend, get some rest. If it rain, so kind of stay in a little bit. Quorum called before adjournment.
Madam Speaker.
Clerk will take the call. There being 128 members present, the House is still in session. Recognizing Majority Leader.
Thank you, Madam Speaker. I move that the House recess until Tuesday, March 2nd at 10 a.m., legislative date